Good afternoon, one and all. And to learn the nuances and the interplay between Section 482 of CRPC and Article 226 of the Constitution of India has evolved with the flux of time, more recently, though it has always been there. But what is the interplay as to whether they can be utilized together or the petitions for the same would lie separately is one of the issues which normally as a professional one has started thinking about, or they are two different arenas and which cannot be utilized in a common petition as such. These are some of the takes which we always thought to understand. And on this, we thought that who else could explain it better, who has created his niche within the profession and beyond the profession. Mr. Sandesh Chauta, a senior advocate, a former Additional Advocate General, Karnataka, and who's more popularly known on account of his assistance and his professional acumen during that famous Jayalalitha's case, taking into consideration that their interplay is important and a lawyer who can put the things across. We had requested Mr. Sandesh Chauta, and he was kind enough to accede to our request. And as such, we find him on the platform. When we brought him, I saw that today there was a lot of login and registration on the emails, etc. So it only shows his immense popularity on the topic. And he's known to be an erudite speaker coupled with the immense knowledge he has. Without taking much time, since I know that it's a working day for a professional next day, and we are also closing near the winter vacations, I request Mr. Sandesh to take over and give his insights on this topic.
Namaste. Pleasure to be this evening's resource person. I'm grateful to Mr. Vikas Chatrat for the introduction. The webinar, organized by Beyond Laws CLC, it has enabled the stakeholders to absorb the reservoir of knowledge, which is shared by many eloquent speakers, and I'm certain it will continue to do so and achieve its objective of enhancing the knowledge of the bar. Today, I have chosen to speak on a subject which I'm personally fond of, the interplay or congruity between writ jurisdiction of the constitutional courts and the inherent power under Section 482 of the Criminal Procedure Code. This is an aspect that has been engaging judicial mind for quite some time. When a court of law is vested with a superlative power, and that power is used to attain substantial justice, then there's divinity attached to that power. This is precisely the scope and width of both these powers, be it the power to issue writs, which are written commands, or the power to exercise the inherent power of the High Court. As I will be highlighting in this presentation, the doctrine of judicial review is the meeting point of these two supreme powers. This jurisdiction of the court may be invoked in an apparently inexhaustible variety of circumstances and may be exercised in different ways. The concept of these two powers is indeed so wide and large that it seems to defy the challenge to determine its quality and its limit. Yet, there's always questions about these powers which demand and deserve an answer, such as, what's the nature of this unblinded powers? Its juridical basis? What are its limits? Does it have a capacity to diversify? And the interplay between their jurisdictions. It's in answer to these varied questions that I intend highlighting in this presentation the origin of these jurisdictions, its growth, the recognition of this power under the old and new CRPC, its recognition under the Constitution, its interplay, and what is it that the superior courts constantly ponder over while exercising these powers and certain allied aspects. The focus is more on the extent of the exercise of these powers under the criminal justice system or under criminal jurisprudence. Let me start with the meaning of the words inherent and writ. Inherent means something that's permanent, which is essential, which is vested by its very character. A writ would mean a command. Writs in Indian legal context is a written order from the Supreme Court or High Court that commands constitutional remedies for Indian citizens against a violation of their fundamental rights. The inherent powers of the High Court under criminal jurisprudence is seen under Section 482. The section stands in a solitary splendor. It's not a power which is conferred by the code, but one which the High Court already has in it and is merely preserved and recognized by the code. Therefore, the code does not and cannot regulate its exercise. Coming to the writ powers of the constitutional courts, the power is conferred under Article 32, so far as the Supreme Court is concerned, and Articles 226 and 227 as regard High Courts. Now, issuance of writs would include 5 categories: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. The scope under Article 226, that's the power of the High Court to issue writs, is far wider than that under Article 32. For the reason, Article 32 confines itself for the enforcement of fundamental rights, whereas Article 226 enables the High Court to pass necessary orders not only for the enforcement of fundamental rights guaranteed under Part 3 of the Constitution, but also enables it to pass appropriate orders for any other purpose. The writs are usually called prerogative because they're discretionary reliefs. When it comes to the superintendence, Article 227 enables the High Court to have the power of superintendence over all courts and tribunals coming under their territorial jurisdiction. When are these powers, whether it's inherent powers or writ powers, exercised? These powers, both under Section 482 CRPC and the writ jurisdiction, are essentially used to exercise ex debito justitia, which means to do real substantial justice. They're used to do justice, undo the wrong. While the High Court uses its inherent powers under 482 CRPC, limiting it to the criminal sphere, the usage of constitutional powers under Articles 226 and 227 is all encompassing. Similarly, the Supreme Court exercises its constitutional power under Article 32 and 142 to achieve the very same purpose, that is, to do substantial justice. Now, needless to emphasize that this power of the Constitutional Court to exercise their writ jurisdiction is recognized as a basic structure of the Constitution. This was recognized by the 7-judge bench in the case of L. Chandrakumar in 1997. Now, before considering the circumstances under which the constitutional courts exercise these powers, it may be interesting to trace out the origin of such powers. Origin of both these powers, be it the inherent power or the writ jurisdiction, it can be traced to common law and the England court system. Common law recognized a superior court of record. The superior court of record is a court of general competence which typically has unlimited jurisdiction with regard to civil and criminal cases. In the case of a superior court of record, it is for the court to determine what matter comes under its jurisdiction and what does not. It determines for itself question of its own jurisdiction. According to Halsbury's Law of England, prima facie, no matter is deemed to be beyond the jurisdiction of a superior court unless it's expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless it's expressly shown on the face of the proceedings that a particular matter is within the cognizance of that particular court. Now, this passage, it has been extracted by the Constitution Bench in 1965 in the case of Special Reference 1 of 1964. Therefore, by the very nature of its superiority, the courts could exercise powers to do complete justice. It is this power which was exercised by the Superior Court of Record that came to be recognized as its inherent powers and also the power to exercise its writ jurisdiction. So far as the origin of the two powers, the writ and inherent powers in the courts in India, the first court that was empowered to issue prerogative writs was the Supreme Court at Calcutta, which was established by the Royal Charter in the year 1774. Thereafter, Supreme Court of Madras in the year 1800 and the Supreme Court of Bombay in the year 1823 were given these powers. The three courts, being the creation of a charter, are even now referred to as chartered courts. These three courts were considered Superior Court of Records, and similar to the Superior Court of Records in England, other than its power to issue prerogative writs, it also had inherent powers to do complete justice. Subsequently, in the year 1861, British Parliament passed the enactment called the Indian High Courts Act, and the three Supreme Courts were revoked New high courts were established in their place, which was under letters patent. The three high courts enjoyed and still enjoy the original jurisdiction and continue to be the superior court of records and thus have its inherent powers intact. The other high courts were subsequently established, but not under any letters patent, and therefore they don't enjoy the original jurisdiction which the three high courts under the letters patent enjoy. However, they're empowered with the power to exercise their writ jurisdiction, and their inherent powers are recognized under the code. It's interesting to notice that it was in the Code of Criminal Procedure of 1872 which conferred European British subjects a right to apply for an order of habeas corpus before the Presidency High Court, which clearly discloses the close nexus between the criminal law and writ jurisdiction from those early days itself. So far as recognition of the inherent powers of the High Court is concerned, the Criminal Procedure Code of India was more crystallized in 1882, although there have been few codes prior to that, 1861, 1872. And then it was amended in 1898. It's interesting to note that in the CRPC of 1898, initially there was no specific provision recognizing inherent power of the High Court. It was taken for granted that High Court, being a superior court of record, had the vested right of inherent powers and there was no necessity of a formal recognition to it. However, it was only as a reminder that the High Courts have inherent powers to pass orders to render justice that by an amendment in the year 1923, Section 561 capital A was created and added to the 1898 Code. The reason to have added this provision also stems from the fact that by then the Code of Civil Procedure was enacted in 1908, and it contained a specific provision under Section 151, which recognized the inherent power of the court in civil matters. Section 151 reads, "Nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary to meet the ends of justice and to prevent the abuse of process of court." It was seen then that though under the civil code there was a specific section recognizing inherent powers, there was no such recognition under the Code of Criminal Procedure. Therefore, in order to avoid any confusion of the existence of such a power, under the criminal law, Section 561A was added to the Code of Criminal Procedure, with one major difference being that such inherent power was recognized only of the High Court and not the trial court, unlike Section 151 of the CPC. Section 561A of the 1898 Code reads, "Nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such orders as may be necessary to 1. Give effect to the orders under the code, 2. To prevent abuse of process of court, and 3. Or otherwise to secure the ends of justice." If these three circumstances are scrutinized, then it becomes apparent they clearly overlap one another. Securing the ends of justice even covers in it the first two parts, that is, giving effects to the order under the code and to prevent abuse of process of court. The words "to prevent abuse of process of court" or "to secure the ends of justice," they're incapable of any precise definition. The framers of the code could not have provided all the cases that should be included within the meaning of these words. Since this inherent power is so large and wide, it was left to the discretion of the High Court to judiciously use this power. Now, post-independence, the recognition of the inherent powers, the interplay between the provisions under the Constitution and the inherent power of the court. As I pointed out, 561A of the old code recognized inherent power of the High Court. Now, post-independence and the Constitution of India being enacted and adopted on 26th November 1949 and commencing on 26 January 1950, Article 225, it recognized the jurisdiction and power of the existing high courts, which naturally included in it its inherent powers. So also Articles 215, it recognized the High Court to be a court of record, having all the powers of such court, including the power to punish for contempt of itself. It is nothing but recognizing High Court to be a superior court of records, and the natural consequence of it is recognition of its inherent power. The Constitution confirmed and revested in the High Court all the existing powers and jurisdiction, including its inherent powers and its powers to issue writs. So far as the Supreme Court is concerned, in view of the powers conferred by the Constitution to the Supreme Court, there was no need or necessity to specifically confer recognize any inherent power thereto. Supreme Court under Article 129 is recognized as a court of record, and similar to that High Court, it has the power to punish for contempt of itself. As we've seen quite recently, a three-judge bench of the Supreme Court has suo motu exercised this power under Article 129 and has held a well-known advocate guilty of having committed criminal contempt and sentencing him to pay a fine of ₹1. Added to this power, the power of the Supreme Court under Article 142 to pass such orders to do complete justice, coupled with the plenary and residuary power under Article 32 and 136, it embraces the power to quash criminal proceedings pending before any court. This is an ancillary power with no limitation at all. So far as the High Court is concerned, Article 226 and 227, it confirms plenary, summary, preliminary, prerogative, and fundamental powers to the High Court. All these are synonyms for its inherent power. The power under Article 226 and 227 of the Constitution is interchangeable with Section 482 CRPC when it deals with criminal jurisdiction. The objective of both is to aid the process of administration of justice and to prevent abuse of process of court. The High Court is allowed substantial latitude in applying the powers interchangeably. It makes little difference insofar as the nomenclature under which the petition is filed. Therefore, when it comes to the administration of criminal justice, there is a meeting point of the inherent power of the High Court under 482 CRPC and the original jurisdiction of the High Court under Article 226 of the Constitution. If an accused establishes that there is an infringement of his fundamental right under Article 19 or 21 because of the registration of an FIR or because of an investigation thereto, then the High Court can exercise its inherent powers under 482 and it can quash the proceedings. Similarly, if a person has been deprived of his personal liberty without following the procedure established by law, or he has been subjected to custodial violence, then the High Court would interfere by exercising writ powers or inherent powers. So also if it's established that the accused, his fundamental right to speedy trial has been violated for no fault of his, or his fundamental right of speech and expression has been curtailed illegally, or his right to assemble peacefully without arms has been violated, right to privacy being violated, even in such cases, along with the exercise of powers under Article 226, the High Court can also exercise its inherent powers under Section 482 CRPC to undo the wrong. Now, of the 5 writs which the constitutional courts normally exercise, we find that 3 of those writs are normally used, even for the administration of criminal justice, along with the court exercising its inherent powers. The writs which are often used are writs in the nature of mandamus, writ of certiorari, and writ of habeas corpus. Writ in the nature of mandamus is used to issue direction to the investigating agency or to the lower court, be it the trial court or the appellate or revisional courts. Directions could be in the nature of fixing a time limit for trial, ensuring certain privileges to the accused on humanitarian considerations are given, or even directions that orders passed by the trial court cannot be challenged before the High Court, but can only be challenged before the Supreme Court. We've had certain cases of this nature too. Now, writ of certiorari is used to quash criminal proceedings, be it the FIR, charge sheet, or proceedings before the court below. Writ of habeas corpus, it's used to direct release of a person or a détenu found from illegal detention. Now, these are the very powers which the High Court can exercise even under its inherent powers so as to do substantial justice. Almost all aspects of criminal justice system are subjected to the litmus test of inherent powers. Inherent power is applicable in reference to FIR, quashing of charge sheet, discharging an accused, expunging remarks, ordering cause, challenging the grant of bail, and other purposes. Similarly, the supervisionary power of the High Court under Article 227 of the Constitution, it shares qualities with the inherent powers of the High Court under 482 and its power of exercising continuous superintendence over the Court of Judicial Magistrate under Section 483 CRPC. When we speak of superintendence, it's not merely administrative in nature, it is judicial supervision. In a rule of law society, the inferior court should not be allowed to run berserk, and the power under Article 227 provides for an effective control. In criminal justice, the inherent powers under 482 and supervisionary powers under 483, they exist for the very same purpose. They share the same ingredients, have the same character and limitations. If we trace out some of the important decisions of the Supreme Court, which recognize the interplay between the writ jurisdiction and inherent powers, then we can go back to the year 1970. In 1970, in the case of S.N. Sharma versus Bipin Kumar Tiwari, an additional district magistrate was named as the principal accused. Certain applications for preliminary inquiries were dismissed. Matter went up to the Supreme Court, and Supreme Court would hold that in appropriate cases, an aggrieved person can always seek a remedy by invoking the power of the High Court under Article 226, and the High Court could issue a writ in the nature of mandamus, restraining the police from misusing their legal powers. In this case, we see the interplay between the writ powers and the inherent powers. Post 1973, when the new Criminal Procedure Code was enacted, there have been a catena of decisions of the Supreme Court which indicate as to when the High Court would be justified in exercising its inherent powers under 482 or under its ordinary original jurisdiction under Article 226 of the Constitution of India. In 1982, in the case of State of West Bengal versus Swapna Kumar Guha, the challenge was to the validity of an FIR, and this was by way of a writ petition. The three-judge bench would quash the FIR on the ground that the liberty and property of any individual are sacred and sacrosanct, and the court zealously guards them and protects them. Therefore, when there's no offense disclosed in the FIR, the court can exercise its writ powers and quash criminal proceedings. Here again, we see an interplay between the violation of Article 21 and the prevention of abuse of process of law in this judgment. In 1992, the essence of these two powers, that's the writ jurisdiction and inherent powers, it has been eloquently capsulated in the classical judgment rendered by His Lordship Justice Ratnavel Pandian in the case of State of Haryana versus Bhajan Lal. It is in this landmark judgment that 7 categories of cases, by way of illustrations, that have been laid down when the High Court would be justified to exercise its extraordinary powers under Article 226 or under Section 482, either to prevent the abuse of process or to secure the ends of justice. This categorization holds the field even to this date. The backdrop of the case was that an FIR was registered against Bhajan Lal, a public servant, on allegation of him having acquired disproportionate assets beyond his legal means and thereby constituting offenses under the Penal Code and the Prevention of Corruption Act. Bhajan Lal challenged the same by filing writ petition before the High Court. The division bench of the High Court of Punjab and Haryana, it allowed the writ petition and quashed the FIR. The state of Haryana challenged the order before the Supreme Court, which allowed the challenge, set aside the order of the High Court, and permitted investigation by the police to continue. However, having analyzed the law on the subject and on the exercise of writ powers and powers under 482 CRPC, the Supreme Court would lay down the illustrative 7 categories when the High Court would be justified in quashing a criminal proceeding. These illustrations include exercise of powers to quash criminal proceedings when the allegation in the FIR or complaint, even believed to be true, would not disclose any offense, where no cognizable offense is disclosed and contrary to the provisions of the law, the magistrate has taken cognizance of the offense, where the allegations are so absurd and inherently improbable, which mocks the continuation of the proceedings, where there's an express legal bar in the code, and where the criminal proceeding is manifestly attended by malafides or has been instituted only to spite the accused due to private and personal grudge. Now, while laying down these categories, the court also gave a note of caution that the power of quashing should be used sparingly, with circumspection, and in rarest of rare cases. It also stated that the High Court should not embark upon an inquiry to ascertain the reliability or genuineness of the allegations made while exercising its inherent powers. It also noted that inherent powers does not confer an arbitrary jurisdiction to the court to act according to its whims or caprice. 1997, D.K. Basu versus State of West Bengal. A letter was received by the Chief Justice of India, which highlighted police atrocities. This letter was treated as a public interest litigation and proceedings commenced. In this case, While considering custodial violence, be it torture, rape, death in the police station, the court felt that there has to be a balance between the right of the investigating agency to investigate and right of the accused individual liberty. The court laid down 11 requirements that a police officer was required to follow, failing which he could be subjected not only to a departmental action, but also proceedings under the Contempt of Court Act. The court also recognized the power under Article 226 of the High Court and 32 of the Supreme Court to award compensation to victims when police atrocity is established. Here again, we see that for a criminal offense, the apex court recognizes the power under the writ jurisdiction to award compensation. 1998, Pepsi Food Limited versus Special Judicial Magistrate. It is in this case that the Supreme Court has again reiterated that it is settled law that the High Court can exercise its powers of judicial review in criminal matters. Under Article 227, the power of superintendence by the High Court is not only of an administrative nature, but is also of a judicial nature. Article 227 confers vast powers to the High Court to prevent the abuse of process of law by the inferior courts and to see to it that the stream of administration of justice remains clean and pure. The court held the nomenclature of the petition, whether under Article 226 or under Section 482 CRPC, is not relevant and is of no consequence. Petition under Article 226 can be treated as one under Article 227 or under Section 482 of the CRPC. It is in this decision that the Supreme Court recognized the doctrine of judicial review to be the meeting point of these two supreme powers. 2010, the Constitutional Bench ruling in state of West Bengal versus Committee for Protection of Democratic Rights. Here, the allegation of an improper investigation in a criminal case. The question was whether the constitutional courts had the power to direct CBI to investigate cases. The Supreme Court recognized the constitutional power both under Article 226 and Article 32 to direct CBI to investigate appropriate cases. Therefore, to enable meeting the ends of justice, which is also what the inherent power aims at, the writ power was clearly recognized by the Constitution Bench. More recently, in 2018, Asian Resurfacing of Road Agency Private Limited versus CBI. Upon a reference as to whether, as against an order of rejection of a discharge petition, will a revision lie, the three-judge bench has considered the powers of the High Court under Section 401, which is the revisional powers, Section 482, the inherent powers, and Articles 226 and 227 of the Constitution. And then it has held, irrespective of the label of the petition, jurisdiction of the High Court is not barred, be it under Section 482 or under Article 227 of the Constitution. This judgment again clearly discloses that the two superlative powers of the High Court, be its inherent power or its powers to issue writs, they coexist to attain the same goal. 2020, more recently, that's on 27/11/2020, in the case of Arnab Goswami versus State of Maharashtra. In this case, the petitioner invoked the writ powers under Article 226 and 227, and also the inherent powers under Section 482 CRPC. He had sought for a writ of habeas corpus, claiming illegal detention, and also sought for quashing of the FIR. As an interim protection, bail was sought for. The High Court denied the interim protection of bail on the ground that the petitioner can approach the jurisdictional court while adjourning the hearing on the prayer for quashing the FIR. This was challenged before the Supreme Court, which granted interim protection of bail and, amongst other aspects, considered the interplay between writ jurisdiction and inherent powers. Upon considering the law on the point, the court would reiterate that circumstances under which the extraordinary powers under Article 226 of the Constitution or the inherent powers under 482 could be exercised, it could be done either to prevent an abuse of process or otherwise to secure the ends of justice. The court also observed that it is not possible to lay down any precise guidelines or rigid formulae to give an exhaustive list of cases wherein such powers should be exercised. Now, this brings us to the most crucial question. While the Supreme Court itself states that the exercise of writ powers or inherent powers cannot be categorized in a straitjacket formula, then what are the considerations for the High Court to exercise the superlative powers? What are its guiding principles? Now, although there can be no inflexible guidelines or straitjacket formula that can be stated, despite that, there are certain basic principles that are relevant to the exercise of these powers when it comes to the administration of criminal justice system. There are about 9 circumstances that I have been able to cull out from various Supreme Court rulings when neither the writ powers nor the inherent power should be exercised. The first of it, the High Court should not exercise its writ or inherent powers when there's a specific bar of law engrafted in the code itself. Although Section 482 begins with the word, nothing in this code shall be deemed to limit. It may be noticed that this is slightly different from the usual non obstante clause, which commences with the word notwithstanding anything contained in this act or any other act in force. Therefore, on first principle, where there's a specific bar in the code, then the court should not try to overcome that bar by exercising its powers, be it writ or inherent. Number 2, not to exercise writ powers or inherent powers when there is an alternate or efficacious remedy available. This is because these powers are more in the nature of residuary powers to be used when there's no other remedy available. Now, it's not that a petition is not maintainable, but it is more so because of judicial discipline. Number 3, the 3 powers are not to be used to stifle a legitimate prosecution. Number 4, it is not to be used when the facts are incomplete or hazy. High Court, while exercising these 2 powers, be it writ or inherent, does not conduct a mini trial or appreciate evidence. It is used only to prevent a palpable abuse of process. Number 5, as against charges framed against an accused. Now, although it can be interfered with while exercising these powers, the same has to be done very sparingly, with circumspection, and that too in the rarest of rare cases. 6, when transactions that disclose both civil as well as criminal disputes. There are certain offenses, a breach of trust, cheating, which involves both a civil wrong as well as a crime. In such cases, the power is not to be used to quash the criminal proceedings where the allegations clearly disclose the ingredients of the offenses alleged. 7, not to grant anticipatory bail or bail by invoking inherent powers. Now, this is because Section 437 to 439, their independent provisions, they require certain prerequisites for its consideration. Therefore, when there's a specific provision covered under the code, the High Court should not transgress that provision in the guise of exercising its inherent powers. Now, this was a view in state of Telangana versus Habib Jilani, 2017. However, it is not that the High Court does not have the power to do so. Now, a 7-judge constitutional bench in the case of Kartar Singh versus State of Punjab in 1994, it observed that if the High Courts entertain bail application invoking their extraordinary jurisdiction under Article 226, then the very scheme and object of the Act and intentment of the Parliament would be frustrated and defeated. But it cannot at the same time be said that the High Court has no jurisdiction. In rare and appropriate cases, in extreme circumstances, and very sparingly, the High Court can exercise its powers under 482 or under 226 and grant bail. Now, one such extreme circumstance we have seen in recent days is in the case of Arnab Goswami, where although the High Court refused to exercise its extraordinary jurisdiction under 226 to grant bail, the Supreme Court reversed the same and granted bail to the petitioner. 8, not to be exercised when the subject matter is covered under certain specific provision in the code. Now, take for example, there's an order of conviction. There lies a statutory appeal. Instead of availing the statutory remedy, if the accused invokes the jurisdiction or inherent powers, then it should not be exercised. 9, in non-compoundable cases, which involves offenses of serious nature, which affects the society at large, and which in fact affects the very fabric of the nation. It could be huge economic offenses or prevention of corruption cases. Then even in such cases where victim and accused, they intend settling their differences, the court should not exercise its writ powers or inherent powers and quash such proceedings. Now let's examine some of the circumstances where the High Court can exercise these powers, both writ and the powers under 482, for the administration of criminal justice. Although there are a number of landmark judgments post Bhajanlal, we can still safely say that even to this date, when the High Court considers exercising its inherent powers or writ powers, it would always use Bhajanlal's case as its pointer to see as to whether the case in hand is fit enough to quash or not. Other than the list of illustrations given in Bhajanlal's case, the apex court enumerates the categories or circumstances which would ordinarily be ideal for the High Court to exercise its inherent powers. I have called out some of the circumstances when the court would be justified in quashing the proceedings. One, as distinguished from serious offenses, there may be criminal cases that are overwhelming or predominantly they have element of civil dispute. By mere clever draftsmanship, a cloak of criminality may be sought to be given to such dispute. We see instances of these cases in commercial transaction, contractual disputes, which do not have the element of criminal mens rea, but still criminal proceedings are initiated only to arm twist the debtors to pay up. In such cases, the High Court may exercise its writ powers or inherent powers to prevent abuse of process of court and to meet the ends of justice. Two, when offenses are again not serious in nature, to categorize them as offenses against the society at large. And though the offense is categorized as non-compoundable offense under the code, if the parties intend settling their disputes mutually, then the High Court may exercise its writ powers or inherent powers to quash the proceedings. We had Gyan Singh's case on it, and we also have State of MP versus Lakshmi Narayan, which is more recent in the year 2019 on this. Three, where there's been registration of an FIR or filing of a complaint under Section 200 CRPC against a medical practitioner alleging criminal negligence. If this is done without following the mandate regarding obtaining third-party opinion prior to initiation of proceedings as laid on by the apex court in Jacob Matthews' case, then the High Court, using its powers, may quash the proceedings. Four, where the orders under the code or the mandatory provisions under the code, if they are not scrupulously followed, then the inherent power can be used to pass such orders as may be required to give effect to the various provisions under the code. Now take, for example, the magistrate on receipt of a B report. He does not follow the mandate under the code, but merely takes cognizance of the report. Then the High Court would exercise its inherent powers and set right that illegality. Similarly, if a complaint is referred for investigation under 156(3) CRPC without due application of mind, or if cognizance is taken in a mechanical manner without judicious application of mind, or issuance of process without proper judicial scrutiny to the allegations on record, these are all instances where inherent powers or writ powers are exercised to set right the illegality. We have Maqsood Syed's case in the year 2008, Anil Kumar versus MK Ayyappa in the year 2013. We have Pepsi Foods, that was in 1998. And more recently, Priyanka Srivatsa's case in 2015, where summons which were issued without application of mind had been quashed. 5. So also, if a complaint has to be referred for investigation under 156(3), without that complaint being accompanied by an affidavit of the complainant to the effect that he has unsuccessfully approached the police for registration of FIR, then the High Court may exercise its inherent powers to set aside the 156(3) reference, Priyanka Srivatsa's case. 6. To give effect to law laid on by the apex court. Now, it is in this context, the order passed by the Constitution bench in Lalita Kumari's case is most relevant. Lalita Kumari's case, what happened was, the informant, a father of a kidnapped daughter, he would go to the police station to get an FIR registered. Although the allegation disclosed a cognizable offense, the station house officer, he refused to register the FIR. Therefore, the point that came up for consideration before the Supreme Court was whether the station house officer is bound to register the FIR if the allegations disclose a cognizable offense, or whether he has the power to conduct a preliminary inquiry in order to test the veracity of the information. The Constitution bench has held when the information discloses a cognizable offense, then it is mandatory for the police to register the FIR and commence investigation. They have no jurisdiction or power to refuse registration of the FIR. However, as an exception in about 5 categories of cases, the police can conduct preliminary inquiry to ascertain whether the allegations constitute a cognizable offense or not. And then, if cognizable offense is disclosed, to register the FIR. This preliminary inquiry has to be completed within 7 days. However, subsequently, it was modified to 15 days in normal cases and 6 weeks in exceptional cases. The 5 exceptions as illustrations where preliminary inquiry is permitted are matrimonial disputes or family disputes, 2, commercial offenses, 3, medical negligence cases, 4, corruption cases, and 5, cases where there's an abnormal delay or laches in initiating the criminal prosecution. This is the ratio laid down by the Constitutional Bench. Question that arises is, despite such a ratio being laid down by the apex court, what is the remedy to an informant if the investigating agency does not follow the ratio? Now, the ratio, it becomes the law of the land under Article 141 of the Constitution of India. The answer to this is to invoke the inherent power or the writ power of the High Court, which could pass suitable orders to ensure compliance. This is to give effect to the orders passed under the court. 7. Similarly, the High Court can exercise its inherent powers to give appropriate directions to the investigating agency, even regarding circumstances not covered by the code. For example, the code does not prescribe an outer limit for completion of investigation. If in a given case there's an abnormal delay in investigation, then the High Court can direct the investigating agency, considering the aspect of the fundamental right guaranteed under Article 21, they can direct them to complete the investigation within a time-bound manner. So also, if the investigating agency deprives the accused of any right, like his right to consult a lawyer or have the presence of his lawyer at the time of questioning, then the High Court can exercise its writ powers or inherent powers to ensure the protection of such rights. 8. Quashing a second FIR on the same cause of action. The High Court, by adopting the doctrine of the test of sameness, can exercise its inherent powers or writ powers and quash a second FIR so as to prevent abuse of process of court and to aid the ends of justice. This was held in T.T. Anthony's case in 2001 itself. 9. The High Court also has the power to pass suitable directions to the trial court or any other subordinate court. They can direct the lower court to complete the proceedings within a given time. However, there's a caveat to be added here. While passing orders to expedite trial, the Constitutional Court should not enter into the realms of legislation by fixing a period of limitation to complete the proceeding, failing which the accused would get a right to an order of discharge or acquittal. Now, there's a backdrop to this caveat. In recognition to the right to speedy trial under Article 21, the apex court in the case of A.R. Anthule in 1992 gave certain directions. There were about 11 directions, but not to the extent to recognize any right of either discharge or acquittal in cases where trial is not completed within a time-bound period. However, subsequently, in Common Cause 1 and 2 and in Raj D.O. Sharma 1 and 2, the right of an accused to be discharged or acquitted if the trial was not over within a fixed period was laid down by the apex court. Now, since there was a conflict between Anthule's case and these two cases, that's Common Cause and Raj D.O. Sharma, the apex court in the year 2002, in P. Ramchandra Rao's case, it referred the matter to the Constitution Bench, which upheld the view taken in Anthule's case, and it rejected the direction regarding limitation fixed in Common Cause and Raj D.O. Sharma's case. The Constitutional Bench held fixing the period of limitation is in the realms of legislation which cannot be done by the judiciary, and the same will not come within the framework of judicial law-making powers which are available to the Constitution Court under Article 32, 141 or 142. Therefore, all that is recognized is to pass suitable directions to expedite trial, but not to fix a period of limitation after which an accused should be entitled to a right of either discharge or acquittal. 10. Writ powers and inherent powers can be exercised even suo motu. If a magistrate passes an order without jurisdiction, this comes to the notice of the High Court, which then can exercise its suo motu powers and set aside the same. Therefore, the High Court has a power to provide relief to the complainant or accused even when they have not approached the court. 11. Orders which are purely interlocutory in nature. Now, there's no remedy under the code to challenge the same. When you don't have any other remedy and the order is interlocutory in nature, you can always approach the High Court either under writ or under 482 and seek remedy against it. 12. In summons cases, there is no provision to seek discharge of an accused. Then if there's a case made out that the ingredients of the offense are totally lacking, at that point of time, the accused can always come before the High Court and seek for exercising its writ or inherent powers to quash the proceedings. This has been held in Adalat Prasad, a 3-judge bench case in 2004 itself. 13. There is no concept of vicarious liability under the penal code. In a given case, if the allegation is only against a corporate entity, say a company, but summons is issued to the directors for alleged penal offenses, then the High Court can exercise its inherent powers to quash the same. We have Sunil Bharti Mittal's case in 2015, which also dealt with the doctrine of alter ego. 14. Orders which are not purely interlocutory in nature, but are intermediatory in nature. Now, this word intermediatory, though not in the code, has been coined by the Apex Court in Madhulimay's case, 1977. Under the code, we find only 2 categories of orders. Interlocutory orders, which are innocuous orders like adjournments, orders, and even grant and rejection of bail. And final orders. Final orders are orders of acquittal or conviction. But in Madhulimay's case, the court observed there can be some orders which are not purely interlocutory, nor can it be categorized as final orders, but orders which affect the rights of parties. Now, orders such as issuance of summons to an accused, an order of rejection of discharge. It's this categories of orders that are termed as intermediatory orders. It is this category of intermediatory orders that can be challenged by invoking inherent powers of the High Court under 482 or under Article 227, notwithstanding the fact that the revision may also lie against such orders. This position of law was laid down by the 3-judge bench in the case of Asian Resurfacing of Road Agency Private Limited versus CBI in the year 2018. 15. Whether a statutory bar affects the inherent power or the writ power. If there's a statutory bar in an enactment, say Section 13(3)(c) of the Prevention of Corruption Act, which prohibits stay of proceedings under that act, even then, this statutory bar will not affect the writ powers under Article 226 or 227 of the Constitution, or the inherent power of the High Court under Section 482 to stay the proceedings in appropriate cases. This has been emphasized by the Supreme Court again in Asian Resurfacing case itself. Lastly, challenge to an order granting bail or anticipatory bail. Seeking cancellation of bail is different than to challenge the very order of grant of bail. What if the order of granting bail is unjust, illegal, or perverse? The challenge to the grant of bail could be on the ground of non-application of mind on the part of the court granting bail, or the opinion of the court granting bail not being borne out from the records. Since an order of bail is a purely interlocutory order, there can be no challenge to it either under the appellate jurisdiction or revisional jurisdiction. And since for cancellation of bail, there are only limited grounds available as held by the Supreme Court. Therefore, exercising prudence while challenging an order of grant of bail, along with a challenge under Section 439(2), it may also be advisable to invoke writ jurisdiction or inherent powers or both. Under these powers, the court can pass necessary orders to meet the ends of justice. This is again one more example where the court exercises its writ or inherent powers. There are numerous other circumstances under which these powers can be exercised merely because the power is so wide, unlimited, and discretionary. The only power is what the court itself decides as its limit. The restraint to this power is self-imposed. Now, with great power comes greater responsibility. So the power is wide, it has to be used wisely. However, it cannot be emphasized enough that the usage of such a wide power is very much required to do substantial justice. How this power is to be used depends on the capacity of the judge dealing with this jurisdiction. The personality of the judges provide for the maturity with which the situation is faced. A judge who is sound in his understanding of men and matters and has immense common sense can do substantial justice while exercising these superlative powers. Court should not hesitate to quash proceedings when the occasion arises. The provisions for discharge, appeal, or revision is no substitute to the remedy of either writ or inherent powers. The court cannot turn a Nelson's eye when there's a sheer abuse of process of court. When there's an apparent travesty of justice, the exercise of these powers is nothing short than a Hobson's choice. There are numerous frivolous criminal litigations pending in courts, and its initiation and continuation is not to attain the ends of justice, but it is aimed at being vexatious, vindictive, and is merely to cause harassment to an accused. It is in such cases that the High Court should not hesitate to quash the proceedings, which will not only save valuable judicial time of the courts below, but will also aid in reducing the ever-growing pendency of cases. The exercise of such superlative power is a need of the hour. In conclusion, it is in this manner that there is intertwining, overlapping, and interplay between the writ jurisdiction and the inherent power of the High Court when it comes to the administration of criminal justice. I do hope that this presentation can be aid to certain budding advocates and to the law students to unravel the conundrum of these two powers of the constitutional courts. I'm deeply grateful for your time, and it's over to you, Vikas.
Yeah. It was an excellent session, and this is by Oath. No, this is by Kumarappa. Can we file bail application under section 439 directly before the High Court? In what situation can it be filed directly without approaching the session court? Same doubt with the anticipatory bail. Is it audible? Unmute. Yeah.
Yeah. Now I think now I'm unmuted. Yeah. See, the powers under 439 and 438, they're concurrent powers with that of the Sessions Court. Now, though it is concurrent powers, we have a number of rulings which say that you should first try and exhaust the remedy before the Sessions Court, before you come to the High Court, which can reappreciate the manner in which a bail or an anticipatory bail application has been considered. So though we can say there's no specific bar, but the High Court on judicial discipline will require you to exhaust your remedy before the concerned court, which could be the Sessions Court insofar as 438 is concerned, and thereafter approach the High Court. This would be so. But in appropriate cases where they find, like we have seen in Arnab Goswami's case, it can be done. It's not that it cannot be done, but it's done only in extreme circumstances.
I'll just check out because on the platform we don't have any question, whether there is any question on the Facebook. No, we haven't any question, but normal question I will just ask because many people want to ask since we are discussing on the criminal jurisprudence also. Like, let's assume the complainant has not made a party and you want to oppose that person. So what would be the right of the complainant regarding appearance at the first instance?
The complainant before the High Court? If he's not willing.
Yeah, before the High Court I'm talking about.
Yeah, okay, okay. See, before the amendment of the code in 2006, the only known manner in which a complainant could have been a party, we get it under section 3012, where the complainant with the leave of the court could engage a counsel to oppose any petition. But post this amendment in 2006, the victim would also have certain rights, because what they recognized in that amendment is, as much as the interest of the accused to be safeguarded, at the same time, even the rights of victims to participate in criminal proceedings also have to be recognized. So with the amendment coming in, if we see section 24, the proviso, section 24, subsection 8 proviso, now it enables, with the permission of the court, for a victim to have a say in the matter. Now, the difference between the two is, under 3012, you will find that there's no right of audience that a complainant can have. But in so far as 24 subsection 8 proviso, it could be construed that you also get a right of audience before the higher courts on the ground that you're a victim and you can participate in it. And other than this also, we find that in a number of other aspects, there's participation of the complainant, whether when he is going to be challenging the grant of bail or cancellation of bail, his right is recognized. Under 482, it is necessary to make him a party where they're seeking for quashing of proceedings. Then when he goes for seeking transfer of proceedings from one place to another, the right is recognized. So we already have certain rights under the code which are recognized, but it becomes more crystal post this 2006, the amendment that has taken place, and the proviso to section 24(8), which has been inserted.
Yeah. Naveen Kumar, is it mandatory for the police to register a FIR when the case is transferred for investigation under section 156(3)?
Of course. The police, at that point of time, the station house officer, he has no discretion at all. So once a private complaint is filed under 200 and the court thinks it fit not to take cognizance but to refer it under 156(3), thereafter the station house officer has absolutely no power but to register the FIR, conduct the investigation, file his final report under section 173. It could be a B report, it could be a charge sheet, or a C report. But it's mandatory for him to register it.
The rest of the questions are different, but one question I feel it somewhat is interrelated to this session. This is by Mratunjaya. Usually High Courts dismiss 482 petitions only because charge sheets had been filed. What would be the remedy? To challenge the charges, or we can still press with the 482 petition?
We do have two decisions of the Supreme Court. See, normally what happens is, at the stage of investigation, if a 482 petition has been filed, and prior to consideration of the same, if a charge sheet is filed, the investigating agency comes and says charge sheet is filed, the petition is not maintainable. But now Supreme Court in two rulings have said no. All that is required is for an application seeking necessary amendment, and in the very same petition, you can continue seeking quashing of the charge sheet that has been filed. So at present, the law would be that even post filing of charge sheet, all that will be required is an application seeking amendment and the challenge to the charge sheet itself. That would suffice.
But in that particular case, large number of courts normally say that it's better you withdraw to file a better one, rather than making a bulkier petition.
Yeah, just rather than making it bulky, they say instead of doing this dual process, why don't you withdraw it and file a fresh petition? That's how they go about it. But the Supreme Court says it is not required. Now, when you have challenged the FIR and a charge sheet is filed, file an amendment, challenge the charge sheet itself. That's how it is gone about.
No, otherwise, even in the under 226, once you move an application read with Order 6 Rules 11 also, then also it does happen.
It does happen. I do agree.
Normally they will say, because then you have to explain in terms of Order 6 Rule 17, stating there in what particular para you are changing. So normally the judge says it's better to
becomes withdraw. More cumbersome, basically.
And they also say that if at all there is an interim protection, we can protect you till you file a fresh one.
Absolutely. That they can do. Powers under inherent powers. They can do that. They can do that.
This is by Vani Goda. Please explain interlocutory in nature and intermediary in nature, and also Sunil Bharti's case.
Now, under the code, we have only two kinds of orders, like I pointed out. One you have is the interlocutory orders, and then you have the final orders. Now, when we say interlocutory orders, these are very innocuous orders. Now, if there's going to be an adjournment done from date A to date B, that adjournment is considered as an interlocutory order. And on interpretation, even so far as bails are concerned, they come under the category of interlocutory orders. Now, when you come to the other extreme, the final orders, it is only cases of conviction and acquittal which are considered as final orders. There may be many situations that come between the two. Now, between the two, when we say where rights of the parties are affected, one more way of putting it across is if an application that has been filed, if it was to be allowed, if it gives quietus to the entire proceeding, then we can say those are applications which were affecting the rights of the parties. Now, it is this category. Now, whether it is issuance of summons, if there was no issuance of summons, probably the witness need not have come, or an accused summons being sent, he need not have appeared. Any kind of order which affects the rights of parties. Another example, a discharge application being rejected. If it was to be allowed, you would have been out of the litigation. Now, these are orders for which the court coined out a word in saying we put this under the category of intermediary, which are not interlocutory nor final. Now, when it's intermediary, which affects the rights of parties, then the right to prefer a revision against its rejection, right to invoke inherent powers, right to exercise the writ powers are all considered as relevant. This is where intermediary comes. And the second question was on Sunil Bharti Mittal's case, right?
Yeah.
Okay. So in Sunil Bharat Mittal's case, what actually happened was the charge sheet was filed only against certain companies. However, the Sessions Court, he issues process to the managing directors of those companies. So the managing directors filed writ saying, look, the complaint is against the companies. The charge sheet is against the companies. You can't issue summons to us. Though the Sessions Court and High Court did not give any approval to such kind of an interpretation, when it went up to the Supreme Court says, under criminal law, you don't have vicarious liability, which means if the allegation is against an corporate entity, it's a corporate entity alone which should be an accused. You can't have vicarious liability of making the directors and managing directors as parties. So they coined what is known as the doctrine of alter ego. And then they said, so far as in penal code, there's no recognition of vicarious liability. You can't proceed against the director or managing director unless there's specific allegations made against them. Now, vis-a this, if you see any other special enactment, 138 of the Negotiable Instruments Act under 141 offense by companies, there the concept of vicarious liability is taken care of to say both the corporate entity and persons in charge of the day-to-day affairs, they are made liable. But such kind of provision not being there in the penal code, the Supreme Court in Sunil Bharti Mittal's case said no concept of vicarious liability. You can't proceed against the managing directors or directors. This is what happened there.
Then this is by Madhusudana Reddy. It says, what is the fundamental difference between 226 and 482 when it can be invoked on the criminal jurisprudence side?
I think my whole interaction today was to mainly to show that there's no difference between these two powers when it comes to the exercise of criminal jurisprudence. Now, even if for a reason you file it under 482, the court will say, all right, we treat it under 226, 227, we quash the proceedings. They use the powers of writ of certiorari. Vice versa, if it is filed under 227, superintendence, the order of the lower court not being its powers illegal, the court still has the power to say, we will exercise 482 and quash it. So the entire thing, insofar as criminal jurisprudence is concerned, don't go by the nomenclature. Don't go by the label to the petition. The powers that they exercise are one and the same. It is aimed at attaining ends of justice. This is how it is. So there's no major difference between the two.
No, I will stay a step further. Sometimes this difference of 226 and 482 comes into being because sometimes as a lawyer, one feels that this particular bench on the 226 gives a more expansive interpretation, and this particular bench will do. So that is where they say that a street smart lawyer would try to play with the
choose the forum that he wants to appear before.
But normally in our High Court, they say you go under 482 once there is a specific remedy out there.
Same thing even in Karnataka, what they do is any quashing of criminal proceedings, it will be placed before the very same judge who deals with 482s. So you may put the nomenclature as Article 226, 227, but it will be treated as one read with 482, placed before the same judge before whom 482 is there. Now, just taking it one step forward, because of Asian resurfacing case, the recognition of not just the recognition is not just of writ and inherent power. There's recognition even of the revisional courts. So, which means against an order of rejection of discharge, I can choose either to go to the revisional court, or I can choose to go before the writ court, or I can choose the court which deals with 482. I have 3 options there.
No, but in that eventuality, the self-restraint comes from the court, not by a lawyer's choice.
Absolutely. Correct. I
read it in one of the lawyer's office before, once you enter to this his chambers, it was written, whatever may be the opinion, ultimately it is the final decision of the court which will prevail.
Absolutely. That's right.
So he says that in case of any adverse order, I can say that you have read what you before entering my chamber.
Correct. He's playing it safe.
Yeah. 2-3 people have asked, could you just explain that Arnab Goswami's case again?
Okay. In Arnab Goswami's case, post his arrest, they straight away moved a writ petition under 226 and 227 read with 482. Under 226 and 227, according to them, it was a case of illegal detention. Therefore, it should be a writ of habeas corpus for his release from illegal detention. That was the prayer insofar as the writ is concerned. So far as seeking quashing of the FIR, they placed it under section 482 for quashing the FIR. Interim prayer which they sought was, till you consider the main matter, please grant bail. Now, when they asked, please grant bail, it was by seeking exercise of both the powers, either under 226 or 482. Now, what the division bench of Bombay did was, they adjourned the hearing of the main matter, but in so far as the interim protection for bail is concerned, they said, no, you go to the concerned lower court and seek a remedy there for release on bail. We will not entertain it here. This was challenged in the Supreme Court. Supreme Court then says, in appropriate cases, when you're seeing that prima facie the materials constituting the offense are not made out, you definitely can look at granting interim protection of bail. Now there, Supreme Court was met with one challenge insofar as the case was concerned, where they said that, look, under the guise of 482, you cannot grant bails. But Supreme Court pointed out and distinguished that case in saying, that was a case where the Supreme Court had found that there was no prima facie case itself. And under those circumstances, they said, don't exercise your powers and grant bail. So they differentiated the case to say when there's going to be a prima facie case, it's always open to you to exercise your powers under writ and grant bail in appropriate cases. This is what happened in Arnab's case. And the matter has been set for hearing before the division bench insofar as the main matter is concerned.
Yeah. This is by Sajjaram. When charge sheet is filed in a criminal case and trial court does not discharge the accused, even when there is a clear evidence from charge sheet document itself, should we file an appeal against discharge order or quashing of the charge sheet under 482 or under writ petition?
So in that case, as I pointed out, Madhulimay's case, which now has been recognized by the Asian resurfacing case, they would say in case your discharge application is rejected, you have 3 remedies with you. You can challenge it by filing a revision. Of course, you can't challenge it by filing an appeal because filing of appeal is only against a final order. You can challenge it by filing a revision. Or you can also challenge it under section 482 of the CRPC, or you can also challenge it under article 227, power of superintendence of the High Court. So 3 remedies are available, but not the remedy of challenging it by way of an appeal.
Yeah. So, Mr. Chota, we don't have any other questions.
Okay.
Before we part for the day, tomorrow's session would be permissibilities of claims under Specific Relief Act by Shankar Murali, an advocate of Madras High Court. We all know that those who have been connected, there are a lot of YouTube sessions, especially he takes for the judicial officers, young lawyers preparing for the judicial exams or for the law student itself. So do stay connected with us, because even as a professional, one wants to understand what could be the claims which could be claimed under the Specific Relief Act. And thank you, Mr. Sandesh Chota. It was a pleasure hearing you. It was always.
Thanks, Vikas. Thanks,
yeah.
Vikas.
I would share, like what you said it in before these virtual platforms, one could only know that somebody has defended or argued for and against somebody. I take a step forward from Jayalalitha. And normally, if you don't know that, that's what I read in one of the books, Word Power Made Easy. It was read that as long as you don't know the word, while reading that sentence, you will skip that word. So similar is the lawyer's name also. Until unless you don't know, you tend to skip it. With all humility, I would say. So same thing happens with a lawyer only. And once you start reading, then you realize that I'm seeing after these webinars that once you read the judgment, then you realize, oh, he had come on our platform. Same happened thereafter. So it is always a pleasure. It was said that you are an erudite speaker. You can speak extempore and take the entire gamut in a flow. And it was actually a pleasure hearing from you. So everyone stay safe, stay blessed. And as we are approaching the winter breaks, I can only say that God should bless you with the professional works so that you can enjoy the Santa Claus in the right perspective. Thank you, everyone. Namaskar. Jai Hind. Thank you, Sandesh.